Hi Murray and team, thank you for choosing us to provide your business with legal advice. Because we only have a short time, we'll just be giving an overview of some of the legal issues Net-Nanny is facing, but we're more than happy to help you implement fixes at a later date. I'm going to focus on the legal issues surrounding the collection of personal information by Net-Nanny, and Jessica is going to discuss GPS tracking laws and the legality of your camera-filled teddy bear. Under Schedule 1 of the Privacy Act, there are 13 privacy principles which govern the collection of personal information. These principles are applicable to Net-Nanny because you fall under the Privacy Act's definition of an organisation. While the definition excludes small businesses and Net-Nanny appears to be a small business earning less than $3 million per annum, you're excluded from being a small business because you collect the health information of the children you nanny. So, the first principle requires Net-Nanny to provide a free and appropriately available privacy policy which states how, why, to whom, especially overseas recipients, and what personal information Net-Nanny collects, holds, uses, and discloses, and how an individual may access, correct, or complain about a breach of their personal information, and how Net-Nanny will deal with those complaints. So I had a look at your website, but I couldn't see a privacy policy. So while you appear to technically be in breach of this principle, it's an easy fix and something we're happy to help you word correctly in the future and put on your website so it's free and appropriately available. The second principle requires anonymity to be an option for individuals. However, I believe this doesn't apply to Net-Nanny on the grounds of impracticability, particularly regarding the health information. You need to know which information belongs to which child for safety reasons. Under Principles 3 to 7, Net-Nanny can only collect and use personal information which is reasonably necessary for nannying, the primary purpose of the information collection. Therefore, things like a family's income are irrelevant and the information cannot be sold. Therefore, when the student sold the information, Net-Nanny was in breach of these principles. In addition, when collecting personal information, Net-Nanny must, as soon as is reasonably practical, notify the individual of the identity and contact details of Net-Nanny, the means, purposes, consequences of non-collection, Net-Nanny's privacy policy, and the likelihood of overseas disclosure and name of the overseas countries likely the information will be disclosed to. Under Principles 8 and 11, Net-Nanny could not disclose the personal information to the overseas student unless they took steps to ensure the Australian privacy principles would not be breached, the other country had similar privacy protections, and the individuals consented to it, and Net-Nanny must take reasonable steps to protect the information from misuse, loss, unauthorised access, and disclosure. Clearly hiring an overseas student on Fiverr is a breach of overseas disclosure and reasonable protection of the information. Fiverr is for simple tasks which do not require confidentiality or expertise due to the risk of the information being sold, as was the case here. The extra cost of the part-time local employee will be mitigated by the prevention of legal costs. As you can see, there are a number of legal issues regarding your current personal information collection. So now that I've gone through that, I'll pass it on to Jessica and she can go over her topics with you. Thank you.
Thank you, Anthony, and hello, Maria and team. GPS is such an innovative tool, and it's great to see you implementing Geo-technology into your business. But there are a few things you need to be aware of in order to ensure you're on the right side of the law, as it's so important you not only guarantee the privacy of your clients, but also protect yourself from liability. As you've been so incredibly successful and have an annual turnover of more than $3 million, you're actually subject to responsibilities under the Privacy Act. And the principles that Anthony mentioned also govern the way you should be handling geodata. While there's no absolute right to privacy in Australia, it has been recognised by the courts that damages should be available for breach of confidence occasioning distress. The Australian Law Reform Commission has also recommended that federal legislation provide for a statutory cause of action for serious invasion of privacy in circumstances including where sensitive facts about an individual's private life have been disclosed. The organisation is obviously privy to some extremely personal information, and while location tracking isn't illegal, potential legal issues do arise when it's being used in a way to record, track or collect information without someone's consent or knowledge. By analysing data about the location of an individual, a third party may derive or infer personal information, for example, about his or her consumer preferences or social activities, or in the case of Net-Nanny, health data as well. A privacy breach of the health information of children, coupled with the family's GPS location, could have serious ramifications and could cause a significant amount of stress to those families. While some system breaches may be unavoidable, those due to systemic weakness, incompetence, or lack of care may amount to unlawful invasion, which is why it's so vital you're up to scratch with your security settings and procedures. Given the ever-growing popularity of apps, increased scrutiny of privacy practices in the industry can be expected, and it's ultimately in Net-Nanny's best interest to build strong privacy protection. While recommendations are outside the scope of our review, it's really important that businesses adopt a privacy by design approach in order to build data protection upfront in order to facilitate compliance with data protection principles and privacy law. Moving on to the next issue we've identified, we have some serious worries regarding the new product you're about to launch, the hidden camera teddy bear. We can understand the concern that's brought on this product. It's not surprising that families would feel the need to have the comings and goings of their house watched over while they're not around, especially when their children are involved. But there are a whole range of legal issues that arise when you're talking about recording someone without their knowledge. In Victoria, it's actually an offence for a person to knowingly install, use or maintain an optical surveillance device to record or observe an activity to which the person is not a party to without the consent or permission of each party. So what does this mean for Net-Nanny? Nanny cams are fine as long as the babysitter is made aware that they'll be recorded prior to the commencement of their employment. We should also note that while the Surveillance Devices Act doesn't allow for the recording of a private activity to which the device user is not a party, this does not include an activity occurring outside of a building or an activity the participants could reasonably expect might be seen by someone else. So there are other options out there for concerned parents which won't potentially land anyone in any legal drama. Thank you so much for choosing us to provide you with this snapshot of the legal issues Net-Nanny are facing, and we hope this will allow you to evaluate your business with peace of mind.